My name is Marcia Hofmann. I am a senior staff attorney at the Electronic Frontier Foundation. How many of you have heard of us? How many of you are members? Oh,
thank you.
Nice to see you guys. For those who may not be aware, which are not many of you, the Electronic Frontier Foundation is a nonprofit here in San Francisco, and we work to protect civil liberties in the digital age. That's our mission. We have a panel here today full of EFF people and also a couple in the front row. This panel is really not so much about us, yakking at you, but about you asking us questions and us answering your questions about our work. And so without further ado, we're going to each very, very, very briefly introduce ourselves so you have a sense of who we are and the sorts of questions we can answer. As I said, my name is Marcia. I am a member of our legal team, and I work pretty broadly on civil liberties issues. I do privacy, free speech, security-related things. These days, I focus a lot on our Coders' Rights Project, which works to ensure that security researchers can do the cool stuff that they do without legal danger.
Hi, I'm Jennifer Lynch, and I'm another attorney at EFF. And I also work on privacy and civil liberties, but I focus on Freedom of Information Act litigation. So I file requests with the federal government and sometimes state and local governments for information on what the government is doing. And mostly that relates to surveillance and privacy. We have a bunch of really interesting FOIA requests out, and we've gotten some good information on how the government uses social networking sites. We have a FOIA request right now on drone authorizations, and we have a lot of other great stuff. So if you have any questions on that or ideas for interesting FOIA requests, we'd love to hear it.
Hey everybody, I'm Hanni Fakhoury. I'm a staff attorney with EFF. My background is mostly in criminal law, and that's what I primarily do with EFF. I also do some privacy stuff too regarding ECPA, Stored Communications Act, and but mostly criminal law.
Hi guys, I'm Mark Jaycox. I'm the legal intake coordinator, and I'm usually the first point of contact and vet cases, bring them to the lawyers, and do a little bit of research and writing as well.
I'm Dan Auerbach. I am a staff technologist. I work on our various tech projects. Who here uses HTTPS Everywhere, the Firefox extension? Oh, awesome, a lot of people. So there's a big release happening very soon, so look out for that. And I pretty much work on that and the observatory, which is a piece that's being added to HTTPS Everywhere, and also a standalone project as well.
My name's Trevor Timm. I'm an activist at EFF. I do a lot of work on free speech and government transparency issues. So the past few months, I've been doing a lot of work on SOPA, and then WikiLeaks is also another thing I write about a lot. And right now, I'm doing a series of articles on mass surveillance and Western tech companies that sell this technology to authoritarian governments and governments in the Middle East and North Africa.
We also have in the front row two of our staff activists, Parker Higgins and Eva Galperin, and they may jump down if some questions come up that are particularly well suited for those guys to answer. So now we're going to throw it open to you for questions. A couple of quick ground rules. First of all, if you ask us about our cases and specific things going on with our cases, we may have to be a little bit careful with the answers to protect attorney-client privilege. And so bear with us if that happens. The other thing is, if you have a specific legal inquiry about your own situation, don't bring it up here in this open forum, but rather come chat with us later so that we can keep that confidential. And with that, who has questions? One up there. Hi.
Hi. I was wondering if you could briefly talk about the two cases where people have been compelled to give password secrets.
Sure. So the question that was asked is whether we can talk about the two recent cases in which courts have addressed the question of whether people have a Fifth Amendment right not to turn over decrypted information that they have encrypted on their laptops. How many of you have heard about these cases? Okay. I'm not going to be too long about this, but I will talk about it a little bit to kind of give you a sense of what's going on. So a little bit of background. the Fifth Amendment to the United States Constitution says, among other things, that you have a right not to be compelled to be a witness against yourself. Does anybody have a sense where this right comes from? Why do we have this right? Right. And I also heard somebody say torture, and that's very much the historical root of this right. The idea is that the government can't can't coerce you to be a witness against yourself. They have a job, if they're going to prosecute you, to collect information and gather evidence themselves, and they can't force you to participate in prosecuting yourself. They're not allowed to do that. And so the way that the courts have looked at this over time is they say you have a right not to be compelled by the government to give testimonial evidence that is incriminating against yourself. Now, if something is incriminating, what that means is it can be used to prosecute you, okay? And when I say testimonial evidence, I mean stuff that would reveal the contents of your mind. And that is very important. That is the key to this. So the way that this has developed, if you have a physical thing in your possession, the government can get, the government can have the authority to take that physical thing from you. But the Fifth Amendment very particularly protects, what's going on in your mind. And the Supreme Court has held that an act of producing something can have testimonial aspects. So even though you're turning over a physical thing or a tangible thing perhaps, it still reveals something about what's in your mind. And that is really the deal here that we're talking about.
So like telling them where the body is?
Like telling them where the body is. Well, here's one way to think about it that involves something very, very tangible, right? Let's say that the government suspects that you shot somebody, and they say, on the one hand, they say, give us the gun with the serial number, blah, 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 blah. Now, if you have that gun, you may have to turn it over because, basically you're just admitting that you have this particular gun in your possession. But if they say, give us the gun that you used to shoot that guy, then when you're turning over that gun, you're basically admitting that you used this gun to shoot that guy. And that is something that reveals something about your knowledge, right? So I think that that's a really good way to think about it because this whole Fifth Amendment stuff can get really kind of tricky and muddled. So, okay, the two cases. First of all, there is a case in Colorado going on right now, federal district court in Colorado. There was a woman, she and her ex-husband have been prosecuted on charges related to mortgage fraud. And when investigators were looking into this and gathering evidence about it, they obtained a search warrant, a couple search warrants actually, to seize computers from this woman's home. And they seized several laptops, including one that turned out to have an encrypted hard drive. She and her ex-husband were eventually indicted. Now, here's an important fact about this case. After the search warrant was executed, this woman had a phone conversation with her now ex-husband. He was in prison at the time, and the phone conversation was recorded because he was in prison. And in the context of that conversation, she made a mention to him about this encrypted laptop that had been seized from the home, and she insinuated in the conversation that there was some stuff on it that investigators might be interested to know, but she wasn't intending to turn over the password so that they could get it. They weren't able to break the encryption on the laptop, and so eventually they asked a judge to force her to either type the password type a password, an encryption password, into the laptop to decrypt the information, or to turn over a decrypted version of that information. She challenged that, raised her Fifth Amendment right against self-incrimination, claiming that if she had to do either of those things, that that would infringe her constitutional rights. We filed an amicus brief in that case supporting her. What the judge ultimately found was that because she had admitted in this phone conversation, basically, that there was information on that laptop that investigators might like to see, she really, turning over a decrypted version of that data wasn't going to tell investigators anything more than they already knew, which meant that she really wasn't revealing the contents of her mind so much as just turning over evidence that they otherwise would be able to get. That is known as the foregone conclusion doctrine. And what the courts have said about that is, basically if you're just turning over something that they already know is there, it doesn't really reveal anything about the contents of your mind, and your Fifth Amendment rights aren't infringed in that way. So that's what happened in that case. It has a lot to do with the fact that she had this conversation with her former husband. Well, so here's the thing, right? According to news reports, her lawyer says it's possible she may have forgotten the password. A judge has ordered her to, basically produce the data. We'll see what happens. I can't answer that. I don't know. Hold on one second. Let me just continue, please. I just kind of want to get through this because I don't want to just monopolize this with discussion about these two cases. So the second case you may have heard of, totally different case. I know a lot of people are thinking this is the same case, but it just so happens these two cases have come up at a very similar time. In the second case, there are a lot of facts we don't know. What we do know is that investigators were investigating a man on suspicion of child porn-related charges. They asked a grand jury to force him to decrypt information on several devices they had seized from his home, apparently, a couple of laptops and some external drives. He did not have a lawyer, and yet he raised his Fifth Amendment privilege against self-incrimination, and a judge didn't buy it and held him in contempt and sent him to jail. The 11th Circuit Court of Appeals, which is one of the most conservative courts in the entire country, just last week issued an opinion saying that he had a valid Fifth Amendment right against self-incrimination and that right had been violated. Now, in that case, apparently investigators had no idea what was on these drives. They just assumed that probably there was evidence of a crime on there. And that is, I think, the thing that makes this so different from the case in Colorado, the Foregone case, because they just basically were speculating that there was incriminating information. They couldn't identify with any certainty or particularity that any even existed. And the judge said in that circumstance, the man's Fifth Amendment rights were violated. So those are those two cases. It kind of remains, they're still very much playing out. And as you might imagine, this is a very live legal issue. So if you're interested in this issue, stay tuned and keep reading about them because I'm sure there are going to be further developments. And, that's where it stands right now. Yes?
Is it true that in the Colorado case, the authorities offered her immunity?
Yes, so in the Colorado case, and actually also in the other case, the two witnesses were offered immunity. And here's how immunity plays into this. If you have a valid Fifth Amendment right against self-incrimination, the government can offer you immunity and basically say, if you do what we're asking you to do, we won't use this evidence against you in a subsequent prosecution. Now, if they do that, the information is no longer incriminating, right? Because it can't be used against you. And that basically cancels out your Fifth Amendment right against self-incrimination. Now, in both of these cases, the government said they offered a limited immunity. And they said, we won't use the act of your production against you. So the fact that you are turning over this data is not going to be used to authenticate it or establish that you had control over this. We would have to prove that through purely independent means. The court in the 11th Circuit actually addressed this very particularly. They said that much immunity is not enough to cancel out your Fifth Amendment right against self-incrimination. It would have to be more extensive than merely immunity for the act of production. It would have to extend to anything that they learn as a result of the act of production. And so they felt that the immunity in that case wasn't sufficient. In the Foregone case, the immunity thing was never really discussed very fully because the court held that she never really had a valid Fifth Amendment right to begin with because of the foregone conclusion doctrine. Now, while the government, offered her act of production immunity, and the court apparently held that she didn't need it, in order for the government to force her to turn it over, weirdly, the court did say that the government had to observe that. So that's kind of a weird and interesting little twist. Yes, the woman in the back.
You said that, so wouldn't the password be revealing something that's in mind? She had to password into the computer, even though she said that it could be something incriminating on the drive, is the password itself?
Well, so the question is, isn't the password itself incriminating? So what the court ultimately ordered her to do is turn over so yes, I mean, the disclosure of the password itself, the act of producing the password, I would say is an incriminating act. And I think that, probably the Colorado court would agree with that, although it didn't directly hold that. But, what it said was that in that particular circumstance, since the government had a good enough idea about what they were going to find on the laptop, basically the act of turning over the password, wasn't really something that implicated her Fifth Amendment rights because they already had a good sense of what was going to be turned up. So wait, does anybody have any questions that don't involve these cases? Okay, great. You in the front row.
What teeth is behind either the Freedom of Information Act or the California Public Records Act with respect to denial of requests from a government agency?
Well, so if you're an attorney, you can file, if you're anybody, you can file a lawsuit against the government. And so that gives you some recourse. One of the nice things about filing a lawsuit against the federal government is that then you get the Department of Justice attorneys involved, and sometimes they are better at dealing with truculent agencies than just the FOIA requester. So that's one thing that helps. If you're an attorney who files a case like we are at EFF, we can get attorney's fees if we substantially prevail on lawsuits. And that's true under California Public Record Act law as well. If you are filing a lawsuit pro se, you're not an attorney, so you can't get attorney's fees. And I would think that that's probably true under California law as well, but I don't know the answer to that for sure.
And what about when it's not a specific denial, but when the agency is taking an extraordinarily long amount of time to get back to you?
It's a really good question, and at EFF, we've taken the position that that is a violation of the Freedom of Information Act. Under the Freedom of Information Act, there's specific time periods by which the agency needs to respond to you. And so if an agency takes too long to respond, we will file a lawsuit in that situation if it's something that we consider to be an important issue. So, for example, one of our outstanding lawsuits right now is a lawsuit against the Federal Aviation Administration for information on all of the certificates of authorization they've issued to fly drones or unmanned aircraft in the United States. We filed our FOIA request back in April. The agency failed to respond, and so we filed a lawsuit at the beginning of January. Now, there has been a case pretty recently in one of the D.C. courts where a nonprofit was in discussion with an agency over getting some records. The agency said, we will probably be able to get them to you by X date, and the date was not that far off, maybe a month after that discussion. The nonprofit didn't want to wait and filed a lawsuit, and the court said that the nonprofit was required to wait, that they hadn't exhausted their administrative remedies. That case, I think the court was wrong in its reasoning, and it's not something that we've ever tested because in the cases we've filed, we haven't been in conversation with the agency over a production schedule. So I think that might be a distinguishing fact in that case.
Yes.
Can you talk about some of your efforts of the EFF outside of the United States?
Who wants to take that? Eva, do you want to?
I would just want cooking.
Yeah, so we have a whole international team. Unfortunately, they're not represented here. Eva does a lot of activism internationally, but she has a throat problem right now, so can't talk. But so we have a director of international freedom of expression. We have a couple lawyers who work with international issues, a lot of intellectual property. So recently we've been doing work trying to stop ACTA and its counterpart TPP. It's called Trans-Pacific Partnership. And Jillian York, who's our Director of Freedom of Expression, often travels around the world trying to promote freedom of expression in countries that don't have as robust protections as us. But as far as, did you have specific questions about specific countries, or?
I can also come in here a little bit, but we kind of have, I would say, like multi-pronged approach. I mean, we have one person working on policy at the OECD, EU levels. My mic is screwing up a little bit. So we have one person working on policy. A lot of it focused on the EU is more so like data retention. This individual is Katitza Rodriguez. It's data retention, especially the EDPS, the European Data Protection Supervisor. They are issuing these new legislation, new rules. So they're like, one of these rights that is getting written up a decent amount in the U.S. press is the right to be forgotten. And so they're starting to push these types of rules, and that's going to be, a lot of work in the data retention sphere and privacy sphere at the EU level. We also have another individual working on copyright issues, and that, as Trevor says, more so TPP, ACTA, pretty much, a lot of the international copyright treaties that are happening and have already happened and been signed, like ACTA, in certain places. And then we also have, an international activism team, which Eva is a part of. She also writes on domestic things, pretty multi-use tool like a Leatherman, And so we have individuals writing at the activist level about pretty much, we do a weekly series on, this week in the international level where we kind of collate all the big stories that have been happening. And yeah, I think those are like the three type of prongs where we are at the international level.
Yeah, for those who didn't hear, Eva said the one thing we don't do is file lawsuits on the international level. Yeah, our legal team, our expertise and our licensing is all in the United States, and so we don't do international litigation.
So this is sort of a follow-up on that. Someone mentioned earlier you are initially writing probably the list of countries that are writing potentially undesirable software for Algerian.
Yeah. Sure. So there are about 2 or 3 dozen companies in the EU and the U.S. that have been selling this mass surveillance technology, which basically allows governments to read every email in the country, listen to every telephone call, read every text. But not only that, but they can change emails from en route to the recipient. They can turn on webcams in your laptop. They can turn on microphones in your phone. They can turn your phone into basically a tracking device where even if it's off, they can figure out how to turn it on and track you. And so this industry has been growing for the last 3 years. Right now it's estimated at $5 billion a year, and it's growing by 20%. And so they have these, what they're called wiretappers balls, where 3 or 4 times a year they go around the country, and all of these countries and all of these companies come together, and authoritarian countries like Yemen, Bahrain, Saudi Arabia, before the revolutions, Tunisia and Egypt were 2 of the main examples. And they buy this technology and install it in their countries with the help of these companies. And a lot of times they say they're using it to track terrorists, but what they end up doing is tracking democratic activists, human rights advocates, and journalists. And so over the last few months, as these countries have fallen, Tunisia, Egypt, and Libya, every time reporters have gone into the countries afterwards and gone into these internet monitoring centers and found hundreds of files of all of these dissidents that did nothing wrong besides start protesting. And so a lot of times there's evidence, especially in Bahrain most recently, where there are dozens of people who have been rounded up and tortured, and while they're being tortured, they're being read back transcripts of their text messages and phone calls. So the problem with this industry is it's completely unregulated, number one, and number two, it's very hard to regulate because a lot of it is dual-use technologies. So when you write a definition, a legal definition for this type of equipment, you end up capturing a lot of communications tools that activists use. So in a lot of situations, we end up writing regulations that are so broad that it ends up doing more harm than good. Like, for example, in Syria, there's sanctions in Syria in the U.S. right now, written by 2 different agencies, and what they end up doing is cutting off some technology that the governments use, but it also cuts off, like, Google Chrome and Google Earth. So the activists can't use these basic tools that they may need to communicate or get around. So it can cause a lot of problems. So what we're trying to do is figure out a way to stop these companies from getting this technology, but also protect activists and make sure that things don't get worse. And so it's kind of a very hard needle to thread. And so what we've come up with is we want these companies to adopt their own human rights policies, where they have to go in and investigate their customer beforehand. Because right now, a lot of times, what's happening is they're selling to one person, and then this other person then sells to the government. So the companies can hold up their hands and say, "Oh, we didn't know. We were selling this horrible technology to people who were mass murderers, essentially." We're trying to institute a policy where these companies have to investigate their customers. They have to lay out what their technology does, and they have to investigate the governments where it's ultimately will end up. And this is kind of a procedure that is already used in U.S. law in a bunch of other situations, so it won't be that hard to implement, and these companies already have to follow it in a lot of other cases. So hopefully that will both solve the problem of dual use and this end user problem where they can just kind of claim plausible deniability.
Why does the EFF hate Bitcoin? Anybody want to take that? So, I can talk about it a little bit. I don't think I would say that we hate Bitcoin. We made a decision not to accept Bitcoin. Our legal director laid that out in a blog post, I think pretty fully. And for those who want to really dig into our position on it, I would encourage you to look at that because she's representing the organization's perspective on it there. But I think a big part of it for us is that there are a lot of laws that come into play for a new currency like that are very complicated, and it's not clear yet how those regulations apply. And we didn't want to put ourselves in a position where we were risking legal liability ourselves for accepting it. We take the position that we like to be defending people who are taking risks that put them on the front lines of how technology and the law come together. We don't want to be the one being sued or prosecuted. And so, I think that was really the root of it.
But we don't hate Bitcoin.
But we don't hate Bitcoin. Well, you know what? If somebody were prosecuted for using or accepting Bitcoin, or if somebody ran into legal trouble, that's something we'd be very interested in. I don't think that there's any question about that. It's hard to say before a case actually develops whether it's a case that we absolutely would do, but it's the sort of thing that we are certainly interested in. We just don't want to be that guy.
It's also apt to say that our legal director has a good kind of comment is that we would rather have our resources and time spent helping to defend the people as Marcia said on the front line than using our resources to defend ourselves. And so I think that really, as Marcia said, that really comes to play. Because the more we have to defend ourselves in a legal quagmire or with legal issues, the less time we have to defend, you guys. And the less time we have to apply our resources outside of kind of defending our existence, right? So that's, that's also a very big part.
Shall I take this? Anybody else? I'll take this one.
I have a comment about EU after you're done.
Do you want to go first?
No, you go first.
Okay. So you asked about the Consumer Bill of Rights that the Obama administration recently introduced just this past week. For those who missed this, last week the Obama administration released a framework for protecting consumer privacy in the digital age. Basically, the administration laid out a Bill of Rights, a user Bill of Rights, and said, these are rights that consumers should be able to expect when they're using technologies, and companies ought to respect that. And the administration said that it's going to try to work with Congress to make this Bill of Rights legislation, and to create a situation where if companies agree to observe this Consumer Bill of Rights, then the FTC can enforce any deceptive representations or refusals to thereafter observe the Bill of Rights. And we think that this is a very interesting development. I think that at the end of the day, we'll see how this works, because companies, if they're going to actually ensure that consumers can interact with their technologies in a way that is respectful of these rights, it's going to require a commitment from industry to actually bring that to fruition. And we'll see how that works out. I think that when the rubber really meets the road, we'll see how effective this is. And I think it also remains to be seen whether the administration really can work with Congress to make this a law. But it's certainly a promising development. Now, you asked about how the Consumer Bill of Rights stacks up to the EU's framework for fair information principles, basically. So there are a series of principles that have been out there for a long time that people tend to talk about over and over again when they talk about privacy. And it's basically like, if any law or if any technology is really going to be respective of privacy, it has to observe these basic principles. And these principles have been articulated by different people in different ways. But they tend to boil down to things like, consumers have a right to know what's being collected about them. Consumers have a right to make informed choices about that. Consumers have a right to give permission for information to be collected. Consumers have a right to have the information be maintained in a secure way. And depending on who's articulating these principles, sometimes they're a little more detailed and set out, and sometimes they are a little, kind of spare and scaled back. And the OECD's representation of these principles, the OECD guidelines, is, I think, commonly considered the most kind of, the most fully articulated and protective set of these principles. And, I have not sat down with the Consumer Bill of Rights and the OECD guidelines and compared them side by side. But I do have to say that I actually think the administration's articulation is a pretty good one as they go. It guarantees, I think, a relatively full set of consumer expectations that is in the spirit of the OECD guidelines. And there may be a couple points that have been missed. Like I said, I haven't really gone down and compared them side by side. But it's clear from the paper that the administration released that they're intending to really make this a global international push. And in order to do that, I think that the principles underlying this probably are going to have to be more aligned with the OECD guidelines, because European regulators are going to expect a pretty high level of privacy protection if this is going to be a way forward that complies with their laws.
Oh, and just one more thing. I'm not sure if you were talking about the OECD guidelines or the privacy bill that's before the EU Parliament right now, but that's what I was going to talk about just briefly. They have this section called the right to be forgotten, which actually, in my opinion at least, may go too far in one direction towards privacy and may end up infringing on free speech. But what the right to be forgotten basically is say you are on a social network and you want to get off it. You want to delete your profile and you want to delete your information so nobody can ever see it again. You contact the company and they have to delete your information from their servers too, so they have nothing. But the problem with this provision is that it also says that anybody who's copied that information off of Facebook or whatever it is, to another website also has to remove it. And it makes Facebook liable for that. So taking an extreme situation, if there is a newspaper article where they quote somebody off of Twitter, and then that account decides, well, I want to be forgotten, and goes through the steps, Twitter would be liable for this newspaper article quoting this person, and they would have to get the newspaper to remove it. But you can see like there's endless situations where it could be pictures, it could be anything, where they're copied onto another website or somebody else's network, and it would bring up a myriad of free speech problems. We probably wouldn't have this problem in the U.S. because of our other laws like the First Amendment and CDA 230 and whatnot. But in Europe, it could become a nightmare for these companies. And on the top of that, the penalties for social networks, if they don't comply with this law, are so astronomical, it could end up really damaging their business too.
One last thing I just wanted to add is a concrete thing that we're excited about with respect to the Consumer Bill of Rights is do not track. A lot of the industry leaders have signaled that they're going to sign on to that, and we've yet to see quite how it's going to play out, but that's really exciting for us. For those of you who know what do not track is.
Why don't you explain it?
Yeah, that's a great question. So one of the companies called Neris was involved with AT&T and our warrantless wiretapping case. They were the ones that set up the spy room for the NSA to go through all our emails. And this is obviously a problem here too. But in these other countries, you have, and I'm not excusing the U.S. at all, and we actually are involved in lawsuits with the NSA over that. But in these other countries right now, it's becoming a life and death situation where a great example is the American journalist Marie Colvin, who worked for the Sunday Times of London, who just died last week in Syria. She'd given an interview to CNN, Anderson Cooper, last Monday, where she was talking about how in the city of Homs, Syria, there was no military targets, and that the Syrian regime was lying, and that they were just bombarding civilians. They ended up probably tracking her location by using her satellite phone signal and purposely killing her and the photographer with her. And we've seen evidence of this all over the place. Libya is a great example where they were systematically going after journalists for Al Jazeera, local journalists, democracy rights advocates, and this was all in the process of them saying that they were just going after terrorists. And there's evidence of these people getting rounded up and routinely tortured. And in a lot of these countries, the laws are more opaque than they are here, to put it nicely. These companies are selling to these governments knowing that they don't have laws, or if they do, that they routinely violate them. And they can see this evidence in public places. So, I'm not excusing the U.S. government's approach to warrantless surveillance, but in these other countries, we can see it's just becoming a problem where thousands of people's lives are at risk.
We didn't touch on this previously, but is there not a legal requirement to export technology to certain countries?
There is for a couple countries. Syria is one, and like I was saying before, the definitions they use for the technology can be so broad. Also, like in the United States, the way it works is Treasury and Commerce make these export restrictions, and they do it separately. So in Syria, they write these broad regulations, and then if you want to export communications tools like web browsers or email servers, you have to apply for these exemptions. And it takes a long time, and there are two separate agencies doing it, so it's very confusing for companies when one agency grants it and the other one still hasn't. So a lot of times they just try to stay safe and don't end up exporting this technology. On the other hand, you have these companies that are kind of skirting these export regulations, like Blue Coat Systems from a couple months ago was found to have censoring and surveillance technology working in Syria while these export regulations were going on. The same thing goes with an Italian company called Area Spa, who all through last year was building this giant monitoring center in Syria as the government was escalating violence and as it was killing hundreds of people. It wasn't until Bloomberg reported on this company back in October that anybody knew about it, and by then there had already been 3,000 deaths. Fortunately, because of the report, protests sprung outside their Italian offices, and they ended up canceling the contract before they were completing this huge project. But it just shows the danger of writing broad regulations on one hand because it could hurt activists and because they might end up being able to circumvent them anyways.
Yeah, sure. The answer is getting a little long, so I wasn't sure if I should go into it. But yeah, Do Not Track is basically it's a header that is sent by a web browser that says, "Hey, don't track me." And there's a working group now in the IETF to sort of figure this out, what exactly this means. EFF is among the stakeholders, along with major browsers. If you use Firefox already supports Do Not Track. And the recent announcement that I was alluding to is that Chrome and other kind of major industry players have signaled that they're planning to support it as well. As to the details of what exactly is stopped by Do Not Track, there's still some stuff to be worked out. For instance, click fraud detection requires some collection of information. So it's sort of not yet set in stone what exactly Do Not Track will entail, but the basic thrust of it will be that third-party tracking, so double-click tracking you across many websites, will be prohibited if you set this header, which you can do in Firefox right now. Does double-click on it right now? Short answer, not exactly. No, but there's been some signaling that this will happen soon.
Could you speak louder? I have vaguely, I saw like the blurb about it, but I don't know about it in any detail in order to really comment on it. Sorry.
So we did a FOIA request for information on, I don't know as much about the Printerdots case, so I'll just sort of tell you what I know. For information on potentially whether the government was requiring companies to use technology or to put in sort of a dot technology that distinguishes printouts. And we haven't gotten anything new on that.
I will say that our staff technologist who's done the most work on printer dots, he's not on this panel, but he's been around today. His name is Seth Schoen, and if you want to talk to him more about that, he may still be here, so I encourage you to maybe go to the EFF booth and ask Kelly to point you to Seth if you want to hear more about it. Yes. Wow, that was a softball.
Plants.
You're not a member, are you?
Give us your money.
Yeah.
Moral of the story.
So our funding model, we take funding from a broad source or a broad range of sources, but the vast majority of our money comes from individual donors. And so it's really important for people like yourselves to become members and donate, because it keeps us alive and kicking. We also get some funding from foundation grants, from attorneys' fees, from corporations or the government if we prevail in a case. We do get a little bit of corporate funding here and there, but never to espouse a certain position or work on certain things. We will only take that money to do exactly what we would otherwise do. But the vast majority of our money does come from individual donations. And so if you like the work that we do, by all means, consider giving a donation. Yes, we can comment a bit on that. We have the Coders' Rights Project. It was started in 2007 when Jennifer Granick joined EFF. And the work we do through the Coders' Rights Project is intended to help protect security researchers and others who are exploring cutting-edge technologies, because of a lot of the laws that come into play in those situations are very murky and they're very difficult to navigate. And there's not a whole lot of guidance out there for people who are doing things like encryption research and finding vulnerabilities in technologies. And so Hanni and I do most of the organization's work on that project, and we do quite a bit of counseling. If anybody in this room ever has any questions about the research that they are doing and they would like to discuss the legal ramifications, you should by all means come and talk to us. We will always be happy to talk to you. And we spend a lot of time coming to conferences like this to get to know the community and help out if any legal craziness goes down at a conference. The last time I remember this happening was DEF CON in 2008, I believe, when 3 MIT students were sued by the Massachusetts Bay Transportation Authority to keep them from giving a talk about vulnerabilities in the Boston T's fare system. And we are always on the lookout for cases like that. And if anybody in this room ever, or anybody listening to this on the internet, ever has any trouble from companies, or if you ever hear from the government with respect to security research you're doing, you should give us a call. Anybody else? Oh, I think last question.
Stay tuned. We just did a new centralized scan recently, and we're waiting. We're doing responsible disclosure. There was a RSA random number generator bug that affected a lot of certificates. So before we release this new data set, we're contacting the people who might be affected by that. But stay tuned. Within the next couple months, there should be a new centralized scan data set released.
All right. Thank you so much. We appreciate it.